Fundamental rights are treated under both Fifth Amendment substantive due process and 14th Amendment equal protection. Substantive due process applies if a right is denied to all, whereas equal protection applies if a right is denied to some but not others. Government acts that do not implicate fundamental rights receive rational basis review. Right to privacy is an inferred right that encompasses several rights with varying levels of scrutiny. So strict scrutiny review are the right to marry, the right to procreate, rights concerning family and children, including rights to custody of one's children, right to keep families together, right to control children's upbringing, and rights to contraceptions. Separate or unknown levels of review are rights to abortion, rights to engage in private consensual homosexual activity, right to refuse medical treatment. Right to vote is usually implicated under the Equal Protection Clause, and right to travel is usually implicated under the Equal Protection Clause. Abortion is a substantive due process right included in the right to privacy. This analysis turns on the viability of the fetus. So viability is when the fetus can survive outside the womb. Pre-viability, the regulation must not unduly burden abortion. So states may not prohibit abortion, but may regulate as it does not create an undue burden. Undue burden is spousal notification. No undue burden is 24-hour waiting period, pretrial birth abortion bans, and parental consent requirements. Post-viability is the prohibition on abortion is allowed unless medically necessary to protect the mother's health. Parental notice and consent laws for minors. No undue burden if the law creates an alternative procedure whereby a minor can obtain an abortion by going before a judge. So a judge cannot approve an abortion by finding either A, the abortion is in the minor's best interest, or B, the minor is mature enough to decide for herself. Subsidies. Government has no duty to subsidize abortions or provide abortions in public hospitals. Application. How equal protection applies to federal, state, and local governments. The 14th Amendment Equal Protection Clause applies directly to state and local governments. Equal protection applies to the federal government by incorporation through the Fifth Amendment Due Process Clause. Equal Protection Clause does not apply directly to the federal government. The same analysis and level of scrutiny applies for equal protection analysis, whether it applies through the Fifth or 14th Amendment. Analysis. If you see anything that it could implicate equal protection, ask 1, is there any discriminatory classification? To receive heightened scrutiny, a discriminatory classification must be proved. 2, what level of scrutiny applies to the given classification? There's suspect classification, which receives strict scrutiny, quasi-suspect classification, intermediate scrutiny, and all other alleged classifications get rational basis. Does the classification satisfy the appropriate level of scrutiny? Classifications must be discriminatory to be reviewed under heightened scrutiny or intermediate or strict scrutiny. There are 3 ways to prove discriminatory classification. 1, the law discriminates on its face. By its terms, the law treats classes of people differently. 2, it can be facially neutral. but the law applied in a discriminatory manner. So the law doesn't create a classification by its terms, but does so as applied. For example, only men are arrested under an otherwise valid law. There's a discriminatory motive or purpose behind the law and or application. So this test, the plaintiff must show, one, there's a disparate impact. The law has a discriminatory impact, it creates a classification, and two, it has a discriminatory purpose. So the law was enacted to maintain for reasons involving discrimination. Demonstrating discrimination impact alone is not enough. There must be some evidence of government discriminatory motive. The challenger bears the burden. Burden is on one party challenging the classification to show that it is discriminatory. The following lists classifications and standards of review they receive. Rational basis. 1. Alienage, but only if classification A relates to self-government and the democratic process, or B is a congressional action concerning immigration. All other classifications not qualifying for strict or intermediate scrutiny receive rational basis review, such as age, disability, wealth, or economics. Intermediate scrutiny or quasi-suspect classification include 1. Gender, or 2. Non-marital children. Strict scrutiny or suspect classification, these include race, national origin, alienage, right to travel, and right to vote.